Mentioning our discussion on Limitation Act 1963, you should have some knowledge regarding the history of the Limitation Act. You know, Britishers gave law to us. Prior to that, there was no law. For the first time, Britishers, by passing different regulating acts, they gave law to us. Limitation Act is one of the law that has been given to us by the British people, the British people. So in India, prior to 1859, there was no uniform law of limitation in India. Different rules were made applicable in different courts regarding law of limitation. So here, the English law of limitation was applicable in Supreme Court by the Britishers. So that from time to time, the English law of limitation was being on application in the Supreme Court. So that is, there was no definite or uniform law of limitation till 1859. For the first time, it was enacted in the form of a code. That is, in the year 1859, for the first time, Limitation Act was enacted. So prior to that, there was a confusion in different courts regarding an uncertainty. So again, after this enactment of 1859 Limitation Act, some anomaly came, and again there was that act was replaced in the year 1871. First 1859, this Indian Law Limitation, then that was replaced by another act, Limitation Act 1871. Again it was replaced by the Act, Limitation Act of 1877, and finally, then again it was replaced by Limitation Act 1908. This old law of Limitation Act 1908, that was again a matter of controversy in the bench and bar. So the government of India, that a bill was passed by the Limitation Act in the year 1963 after independence, and that received the assent of the President of India. This is on 5th October 1963. On 5th October 1963, and it was published in this Gazette of India, Extraordinary Gazette Part 2, and it came into force with effect from 1st January 1964. This is called Limitation Act. So this is the Limitation Act. This is history. First in the year 1859, then it was replaced by Act of this 1871, 1877, 1908, and lastly, that is in the year 1963. This present Limitation Act came into force from first day of January 1964. Then what is the object of limitation? Object of limitation. Why a Limitation Act has been passed? The object of limitation is that what it says, the preamble says that a Limitation Act was passed to consolidate and amend the law of limitation of suits and other proceedings. Prescribe limitation for suits and other proceedings and for the purpose connected therewith. What the preamble says? That the Act indicates that the Limitation Act was passed to amend and consolidate the law of limitation regarding suits and other proceedings and matter connected therewith. So this is the preamble of the Act. But the object of the Act is, what is that? Twofold. To quiet long possession designed to bar stale remedy, stale demand. The object of that is to quiet long possession and extinguish stale demand. These two things. Quiet possession. Suppose that is section 27 of the Act provides that if a person is in possession of somebody's immovable property for a prescribed more than a particular period, 12 years, then thereby he acquires a right over that by of adverse possession. That is quiet possession. That is object act is quite long possession. Because of some long possession, that possession will not be disturbed, and also to extinguish stale demands. Stale demands. So this act is not to create or define a cause of action. It doesn't define what is the cause of action, etc. But simply that prescribes a period within which a suit or a right is to be claimed by filing a suit. So that is the enforced right. The principle of the act is not to enable suits to be brought, not to enable the suit, but what? After certain period, there is the law forbids a person to institute a suit. After certain period, prescribed period of limitation, forbids a person to bring a suit or the proceeding in connection with that. So, but you may say the law prescription is there, basing upon the principle that law is the again another principle is that law helps a person who is diligent about his right, who is vigilant about his right, but law does not help a person who sleeps over his right. That is, a man who has negligently slept over his right for an undue length of time will not be allowed to litigate. If a person, that is a lethargic person who sleeps over his right, that means a person who willfully, without any fraud or breach of trust, has been in possession of somebody's enjoyment of somebody's property for a long period, that possession will be recognized. For a period, the law has prescribed, it will be allowed to, then he will be allowed to enjoy that property by adverse possession. Two things. So, that is, he should be allowed. His possession should not be disturbed. This is the limitation. So, law helps a person who is vigilant about his right, but not a person who sleeps over his right. That is, the statute of limitation or statute reports intended to check the tendency of dilatoriness, and they should be administered as strictly as possible in order to strengthen the repose at which they can. Law of limitation is based on the sound principle, that first principle that interest republicae lit sil finis litum. That is Latin maxim. It is in the interest of the state that there should be an end to a litigation. It is an interest of the state, there should be an end to an litigation. The law of limitation limits, because it limits, so that's why we say limitation act. This law of limitation limits or prescribes a time, limits or prescribes a time after the lapse of which no suit or other proceeding cannot be maintained in court of law. So that's why it is called Limitation Act. Limitation Act prescribes a time limit within which a person can institute a suit or other proceeding. If he does not institute that suit or proceeding within that prescribed period of limitation, then that suit or proceeding will not be entertained by the court of law. So that's why it is called, it means that prescribes a period of the institution of the suit and forbids them from being brought beyond after that period. That is, it only restricts the holder of a right from enforcing the right, but and right by recourse to law after the prescribed period. After the prescribed period of limitation, it bars the suit. It forbids that person. It provides that his claim will not be entertained in the court of law. So here, Tukuru versus Tanaji, this case, the Supreme Court held that this Limitation Act apply only to proceedings in courts. Proceedings in courts. And not to appeals or application before bodies and other than court. Any application is filed other than court, that is tribunal, quasi-judicial bodies, tribunal or executive authorities. To those limitation is not applicable. Say for example, motor accident claim tribunal. There are no limitation is applicable there. So that's why it is only applicable to the courts. It is possible that in some cases, the provision of limitation, the right of the holder cause great hardship, and sometimes also general good for greater number. Sometimes it may cause hardship, but for the benefit of greater number of people, such a limitation act has been passed. That is limitation act. That is the nature of the law of limitation. What is it? Is a rule of procedure. Limitation is a lex fori. It is applicable to the forum. So it is a procedural law, or otherwise it is a branch of adjective law. So the intention of the law of limitation is not to create a right where there is none. If there is no right, it doesn't create a right. Not to extinguish a right where there is one, but to interpose a bar after certain period to enforce that right, enforce an existing right. Bar to enforce existing right. Law of limitation is a procedural law. In various cases it has been held, and not personal law. They are applicable to the forum. Being procedural law, it should have reference to lex fori, that is the law applicable to forum which passed the decree, or which passed the decree, that is forum. Suppose when the recovery of debt is bad, suppose again sometimes you get a question, limitation bar the remedy but does not extinguish the right. So in this case, Tilok Singh versus Superintendent of Police, what in this case? Here, when the recovery of debt is barred by lapse of time, the right to debt is not extinguished. Suppose somebody has borrowed some money. So under a contract, he is liable to pay the money. The prescribed period of limitation to recover the money is 3 years from the date when it becomes due. Suppose within that prescribed period, no suit is filed. So suit is not maintainable. But somehow or other, if that person pays that money, and pays the loan amount, so he cannot again file a suit against that person to recover that amount, basing on the pleading that his claim was barred by the law of limitation and he erroneously paid that money and that money was refunded to him. This has been held in Tilok Singh versus Superintendent of Police. What is case? If the debtor, without being aware of the bar of time, paid the money to the creditor. So in such case, he cannot sue the creditor to refund of the money. This is called limitation only bars the remedy but does not take away the right, does not extinguish the right. Only section that is section 27 is an exception. So here still it available. So in Bombay time, so state of Bombay also, it was held that is limitation as distinguished from prescription merely bars the remedy but does not destroy the right which remains continue in other ways. This bars the remedy, but the right still exists and continues, and that is enforceable. That is barred and not. So that is period of limitation prescribed the law. So very agreement which again, suppose a question may come, can the party by entering an agreement extend the period of limitation or shorten the period of limitation? The answer is no, because it is against law. Such an agreement is against law. Such a contract is opposed to law. So that is void. So what the law cannot be evaded by private agreement. By entering agreement, private agreement, the law of limitation cannot be evaded by the parties in between them. Thus, every agreement which shortens or extends the period of limitation prescribed by law is void and not enforceable. This is, so here, this is the statute of limitation bars the remedy but does not extinguish the right. Always you should bear this thing in mind, because most of the time you get a direct question. This in the judicial service exam, the other examination, the statute of limitation bars the remedy but does not extinguish the right. The lapse of time does not extinguish a right of a person because of lapse of time. Since limitation only bars the suit for enforcement of that right, but does not destroy the right itself, or a defense, though he could not have enforced the right by a suit. There is no limitation against defense. However, only in section 27 of the Act provides that the limitation of the period limited by the Act to by person for instant of a suit for possession of any property after the expiry of that period of limitation to recover possession of that property, his right to such property gets extinguished. In such circumstances, he cannot also set up such an extinguished right by way of a defense. This is also a quiet possession. It is burst the remedy and quiet possession. Now a question will come. So far as you know, what is that? Basing on the principle, there should be an end to the end of the litigation. Law helps a person who is vigilant about his right, but not to a person who sleeps over his right. Limitation only bars the remedy, but does not extinguish the right. In certain cases, only exception is section 27. Thereby, the right is not extinguished. That is, interest, if they say there should be an end to limits. If there will be no limitation, there will be lots of anomaly. For an example, if today X files a suit against Y, saying that his father's father had borrowed certain amount from his father's father, and he claims that money from him, what will happen? There will be a lot of difficulty. So there will be no end to litigation. If there will be no law of limitation, what will happen? The litigation will remain immortal when the man is mortal. So that's why, keeping in this thing mind, so in the interest of says there should be end to litigation. So that's why the Limitation Act has been enacted, only that it bars the institution of suit or other proceeding after a prescribed period of limitation. Now, whether limitation is applicable to criminal proceeding, so far as section 468 of the Criminal Procedure Code is concerned, we find there is a limitation for that. If a offence is punishable with fine only, then what is the period of limitation is 6 months, 1 year for 1 year, then up to 2 years, and if 3 years above, that is no limitation. So that is a period of limitation prescribed in section 468 of the Criminal Procedure Code. So, because limitation is generally applicable to civil law, but it is not applicable. But in the Criminal Procedure Code, we find a provision that if the limitation is applicable for taking cognizance of the offence in that chapter. So, why limitation? No limitation of time is there, but when there is delay in filing a complaint, but a complaint is not barred because of delay in filing a complaint. But the chance is that when a complaint is filed after an abnormal delay, there is possibility of what the memory of the witness will fail, will be faded by the lapse of time. Valuable links of evidence may disappear. So to avoid this section 467 to 473 of the Criminal Procedure Code, prescribe limitation. So for institution for taking cognizance of the criminal cases by the courts. So here, that again you should remember, the Supreme Court have observed that now there is only one general law of limitation. That is Limitation Act 1963. All other laws prescribing period of limitation are either special or local law. There may be special or local law. Statute of limitation are statutes of repose, peace and justice. What is that? Statute of limitation are a statute to repose or to give a rest, to quiet title, to suppress fraud, and to supply the deficiency of proof, arising from the ambiguity and obscurity of the antiquity of the transaction. So that's why that is reason the statute of limitation has been rightly termed as statute of repose, peace and justice. Statute to repose, peace and justice. The Romance maxim, that is interest republicae ut sil finis litum, that is, in the interest of the state, there should be litigation should be put an end. Vigilantibus non dormintibus jura Sulebinian, that is, the law assists the vigilant or not those who slept over their rights. So, even on the Privy Council has observed in this Lukme versus Ranjit case, what is that? To secure the quiet and repose of the community is necessary that the title to property and matters of right in general should not be in a state of constant uncertainty. When somebody is right to property, or somebody enjoyment to property, should not remain as constant uncertainty or doubt and suspense. A constant dread of constant fear of judicial process, and a feeling of uncertainty, like that is like a sword of Damocles sword. And it are the growth and prosperity, it will hamper the growth and prosperity of the economy. And is paralyzed when the enjoyment of its fruits are not is uncertain. So that's why the law of limitation prevents such uncertainty. When a person knows after a particular period of limitation is barred, the person cannot file a suit or proceeding to enforce that right, thereby he remains in peace. The statute of limitation is not only a statute of repose and public peace, but it is a statute means private justice, means of ensuring private justice. So all statute of limitation for their object the prevention of the rearing of claimants distant time when evidence are lost. It will prevent a person to claim certain right when the evidence is lost. It is again the principle of justice that a person who has negligently slept over his right for length of time, disproportionately long, he will not be allowed to litigate, and that is respect those rights. You should respect those rights. So now you should know there is a prescription. What is the definition difference between prescription and limitation? Prescription it's been tracked. If for a particular period, if a person is in enjoyment of a particular right, thereby he acquires right over that property by your prescription. So prescription, that is limitation, means after a prescribed period of limitation, no suit or other proceeding can be instituted in court of law. But in the prescription, it is necessary to establish a right by prescription. By prescription, somebody acquires right over a property because of use of that property or occupation of that property or enjoyment of that property for a long period, as allowed by the law. The identity of the thing is enjoyed, that it should be adverse to the right of some other person. Then the law of prescription laid down a period after the expiry of which that that right that right is acquired by the person. The law of limitation bars the filing of any suit, appeal, or other proceeding after the lapse of a definite period in a court of justice. But here, the law of prescription lays down a period at the expiry of which that right is acquired over that property by way of prescription. Limitation only bars the remedy, it becomes an imperfect right. The prescription extinguishes the right. So limitation concerned only in the judicial remedy, whereas prescription affects the substance of the conflicting rights between the rival claimants, and as such comes under the category of substantive law. Limit prescription comes under the category of substantive law because rival claims are settled, is determined there. But here, under the law of limitation, it is a procedure, it only bars the remedy. That is, though a limitation is negative in its operation, depriving a person of power to enforce a right, but whereas a prescription is positive, conferring on a person's right, which is hitherto enjoyed in fact, but not in right. So this is, then you may should compare what is laches and limitation. Laches means negligence or not doing an act within because of delay or one's own right. The doctrine of laches is based on the equity, that is delay defeats equity. Doctrine of laches based on the equity principle of equity, that is delay defeats equity. In the case of equitable reliefs, court of equity in England refused to grant such relief basing on laches, such as to an applicant who has willfully made delay. Delay defeats equity. The principle, the laches principle is applicable in certain interlocutory matters. Application in this country also is also specific performance of contract, temporary injunction, appointment of receiver. In such cases, laches is taken, long delay is taken into consideration. So laches means that is equitable because of long delay. Doctrine of limitation distinguished from doctrine of acquiescence. Acquiescence means what? Somebody acquiescence is an instance of the law of estoppel. By somebody acquiesce does not object, that is will be treated as law of acquiescence. If a party having a right to stand and to seize another acting in a manner inconsistent with that right, if a person has a right, he finds somebody is acting inconsistent with right and makes no objection, while that right is enjoyed, he cannot afterwards complain for it. This is called acquiescence. This is the proper sense. The word is called acquiescence. Suppose acquiescence may be direct or indirect. If a party has a right, if somebody finds somebody is violating his right, he does not object and allow that person to violate that right, then that will be treated as acquiescence. Acquiescence is an instance of the law of estoppel by conduct. It differs from laches. The laches is merely passive without any implication or assent. So the laches may be by laches only passive. It is that acquiescence is an instance of law of estoppel by that is construct that is conduct. That is law only by conduct. Somebody is estopped by acquiescence. The laches like limitation affect the party's remedy, while acquiescence, like prescription, practical destroy the right. Acquiescence, like laches, depends both on general principle and is a prescription is a matter of express and inflexible rule of law. So, burden of proof to plea of limitation. Who will say proof that the matter is? The onus to prove is that the suit is brought, a suit is filed within the prescribed period of limitation, is always on the plaintiff. And he must show either that the suit is prima facie within time, or that the region of minority or concealed fraud, etc., or the limitation has not been expired. The plea limitation can be raised against plaintiff only. That is to be raised against plaintiff only. So here, the general rule is that the plea of limitation can be raised as against the plaintiff, but not against the defendant. The main object of the law of limitation is to prevent the person from instituting a suit or to enforce his statutory demand, and not to prevent a person from raising any defense. It does not prevent a person from raising any defense. The defense will not be precluded from setting up a right by way of defense if you could not have done so as plaintiff by way of substantial claim. So here there is exception. There are two exceptions. First, under order 8 rule 6 of the CPC, a defendant cannot claim to set up a claim in a suit against himself. That is a bar. This setup and counterclaim that is applicable when the suit by the defendant would have been barred under section 25 to 27 of the Limitation Act. The defense cannot set up those things. When the defendant raises a plea of some inchoate or imperfect right, the establishment of which would depend upon a suit within particular time, he should not be allowed to urge that defense. So plea of limitation will take. The plea limitation can be raised at any time. There is no time limit. Any time, even after timing of the, but at the hearing, but the law prescribes at the hearing of the suit before the issues are framed and also after the issues are framed. This plea of limitation can be taken at any time, even after framing of the issue. It can be decided on the existing issue. In an appeal also, or in the second appeal. But when the period of limitation has been raised at a later stage, when the issue in case have been fixed, the case has proceeded to some length, fresh issues of the fact have gone into, and additional evidence is to be taken. In such case, the court has the power that is option of refusing to entertain that plea. Waiver of plea limitation. Can party waive the plea of limitation? It is not competent to a party to waive the plea of limitation, who has to absolve this court from duty. It is the duty of the court to see that the matter, the suit or the proceeding has been filed within the prescribed period of limitation. So that a period of limitation will come with the provision of section 27 of the Contract Act as tending to defeat the provision of the Limitation Act. If a agreement contract is entered to defeat the provision of the Limitation Act, either extending or shortening, that is void. So an agreement not to plea limitation would be void. So that's why the Limitation Act, you may divide the Limitation Act for the better understanding. Preliminary from section 1 to 2, limitation of suits, appeal and application from section 3 to 11, computation of limitation, that is from section 12 to 24, acquisition of ownership by possession, that is 25 to 27, miscellaneous 28 to 31. So this is the preliminary section 1 to 2, limitation of suits, appeal and other proceedings 3 to 11, computation of period of limitation from 12 to 24, acquisition of ownership by possession from 25 to 27, and miscellaneous other sections. So this is the first part of the deals with the definition. The first part, that is definition of the different words which are used in that. The definition of bill of exchange is made good faith, period of limitation, promissory note, and tort. Tort is defined in the Limitation Act, are most important. Part 2, 3 and IV of the Limitation Act are most important. These are, you should also know this. Thank you. In the next class, we'll discuss the enactments, that the language of each of these sections in separate.